In May of 2010, a 16-year-old named Kalief Browder was walking home from a party in the Bronx when police stopped him. Someone had reported that a person matching his description had stolen a backpack 2 weeks earlier. Kalief said he did not do it. Police arrested him anyway. Bail was set at $3,000. His family could not pay it, so they sent him to Rikers Island to wait for his trial. He waited for 3 years. No trial, no conviction, no evidence that ever held up in court. Just a 16-year-old in one of the most dangerous jails in the United States for nearly 3 years because his family did not have $3,000. I am Ben. The Sixth Amendment to the United States Constitution guarantees every person accused of a crime the right to a speedy trial. That right exists specifically to prevent what happened to Kalief Browder, and yet it happened. The question is how? And the answer tells you something important about how the criminal legal system actually works when you cannot afford to make it move faster. The case. Kalief Browder was 16 years old when he was arrested on the 14th of May, 2010. The charge was robbery in the second degree. A man named Roberto Bautista told police that Browder and another person had stolen his backpack containing money, a credit card, and an iPod 2 weeks before the arrest. There was no physical evidence connecting Browder to the theft. There was no video footage. There was a single witness statement from the alleged victim. Browder maintained from the moment of his arrest that he had not stolen anything. He was offered plea deals repeatedly over the following years. In New York at the time, accepting a plea deal would have meant going home. He refused every one of them because he said he was innocent. Bail was set at $3,000. Later, it was raised to $10,000. His family could not pay either amount. And so Browder went to Rikers Island as a 16-year-old pretrial detainee, legally innocent, waiting for a trial that kept not happening. The case was adjourned more than 30 times over, nearly 3 years. Some adjournments were requested by prosecutors. Some were the result of scheduling backlogs. The complaining witness, Roberto Bautista, eventually returned to Mexico and became unavailable. In May of 2013, the Bronx District Attorney's Office dismissed the case. No trial. No verdict, just a dismissal, nearly 3 years after the arrest. Kalief Browder walked out of Rikers Island in May of 2013. He was 19 years old. What Rikers did to him. The legal story of Kalief Browder is about the Sixth Amendment. The human story is about what Rikers Island did to a teenager who had not been convicted of anything. During his time at Rikers, Browder spent more than 700 days in solitary confinement. Solitary confinement means a cell roughly the size of a bathroom, 23 hours a day, with 1 hour of time outside. No meaningful human contact, no programming, no education. The United Nations has described prolonged solitary confinement as a form of torture. Browder experienced it for nearly 2 years, as a minor, before any jury had found him guilty of anything. Surveillance footage obtained by The New Yorker documented guards beating Browder inside the facility. He was also beaten by other inmates. He attempted suicide multiple times while incarcerated at Rikers. After his release in 2013, Browder struggled to rebuild his life. He enrolled in college. He spoke publicly about what had happened to him. His story was published by The New Yorker in 2014 inches apiece by Jennifer Gonnerman that reached a national audience. A documentary series about his case was later produced by Jay-Z. On the 6th of June 2015, 2 years after his release, Kalief Browder died by suicide. He was 22 years old. The Sixth Amendment and why it failed him. The right to a speedy trial is guaranteed by the Sixth Amendment. The Supreme Court established the framework for evaluating speedy trial claims in Barker v. Wingo in 1972. The court identified 4 factors that courts must weigh when determining whether the right has been violated: the length of the delay, the reason for the delay, whether the defendant asserted the right, and the prejudice to the defendant. Browder's case checked every factor. The delay was nearly 3 years. The reasons included prosecutorial requests for adjournments and a missing witness. Browder and his attorneys repeatedly raised the issue of delay, and the prejudice was catastrophic. But here is the problem with the Barker test. It is a balancing test. It does not set a fixed time limit after which a case must be dismissed. It requires courts to weigh competing considerations. And in practice, courts have found ways to justify delays that, described plainly, are indefensible. New York also has a statutory speedy trial law that sets time limits for prosecutors to be ready for trial. Under that law, the prosecution in a felony case must be ready within 6 months of the criminal proceeding beginning. Prosecutorial requests for adjournments do not count against that clock only under certain conditions. Defense requests for adjournments, which sometimes happen at the defendant's request and sometimes happen for other reasons, pause the clock entirely. What this means in practice is that the clock measuring how long the prosecution has to get ready is not the same as the calendar time the defendant spends waiting. A case can drag on for years, while the statutory clock shows the prosecution has technically complied. That gap between legal compliance and human reality is where Kalief Browder lived for nearly 3 years. The bail system that kept him there. None of this would have lasted 3 years if Browder's family had been able to pay $3,000. Cash bail operates on the assumption that money is a guarantee of appearance. If you have enough money at stake, you will show up to court. If you cannot put up that money, you wait in jail. The system does not distinguish between someone who is a genuine flight risk and someone who is poor. It treats inability to pay as equivalent to being dangerous. At the time of Browder's detention, New York's bail system gave judges limited options. They could set cash bail, release someone on their own recognizance, or deny bail entirely. There was no structured framework for assessing flight risk or danger independent of financial ability. The result was a system in which being poor meant you waited in jail, and being wealthy meant you went home, regardless of what either person had actually done. The $3,000 bail set in Browder's case was not a high number in absolute terms. For a family without resources, it was an uncrossable wall. Browder spent nearly 3 years at Rikers Island, not because a court found him dangerous or a flight risk. He spent nearly 3 years there because his family did not have $3,000. New York passed the New York State Bail Elimination Act in 2019, which eliminated cash bail for most misdemeanors and nonviolent felonies. The reform was significant. It was also 9 years too late for Kalief Browder. What this means for you. Kalief Browder's case is not an anomaly in the sense of being impossible to explain. It is an anomaly in the sense that it became visible. The mechanisms that produced his situation, the adjournment culture in overwhelmed courts, a bail system that functionalizes poverty as detention, solitary confinement used on minors, these are systemic features, not one-off failures. If you or someone you know is arrested and cannot afford bail, the pressure to accept a plea deal will begin almost immediately. Prosecutors offer plea deals that involve time served or probation. Deals that mean going home today in exchange for a conviction on your record. That pressure is real, and it is designed to be. The system processes cases through pleas. Trials are the exception. What Browder demonstrated, at enormous personal cost, is that refusing a plea deal is a legal right. It is also, in a system without meaningful speedy trial enforcement, a decision that can cost years. That is not how the right to a speedy trial is supposed to work. It is how it works in practice when the courts are overwhelmed and the defendant has no money. If you are held pre-trial, your attorney should be asserting your speedy trial rights formally and in writing at every court appearance. That creates a record. The Barker test weighs whether the defendant asserted the right. Silence is not neutral. Documenting the assertion of the right is the difference between having a viable legal argument and not having one. The complete picture. Kalief Browder did not steal a backpack. No jury ever found that he did. No court ever convicted him of anything. He spent nearly 3 years at Rikers Island, more than 700 days of it in solitary confinement, because the system moved slowly and his family was poor. The Sixth Amendment was written to prevent exactly this. The courts that reviewed his case found no violation. That gap between what the Constitution promises and what the legal system delivers is not a bug. It is the result of decades of decisions by legislatures, by courts, and by prosecutors that prioritized case volume over individual rights. Kalief Browder was 22 years old when he died. He had been home for 2 years. He had not been convicted of anything. The system is not broken. It is working the way it was built to work. Understanding that is the beginning of knowing how to protect yourself inside it.